Good evening, everybody. It's MC Intimidator, Pete Atkins. I didn't have the opportunity to read last night. I mean, I had the opportunity, but there's just so much to cover when you're going through corruption like this. And they want to claim that, we're crazy. Yet you all aren't offering any other defenses to anything other than some text messages that I've sent. They claimed it was 400 over a 3-month time frame. No, you go back and count them. It's 400 over a 3-year time span. And these messages that they're claiming are prejudicial effect because y'all are using those to mount a defense against me when they were modus operandi created by the entrapment by the courts and the law enforcement officers because of my children being abused, abandoned, and neglected, with the uncontestable evidence and completely admissible in the court of law per Florida statutes 934.03 wiretapping laws, contemporaneous evidence, Florida statute laws, and as well as the Saucier versus Katz test, which again I've covered in prior videos. But I want to read my defense, W.B. Smith, so we can show your unscrupulous practice and incompetence and why you were required by law to recuse yourself during this court hearing when I was just simply requesting a continuance I had the right to have to try and procure witnesses. So let's get into the defense. Your Honor, Florida rules of procedure, because you all cut me off halfway through, didn't even allow me to finish, just like y'all did with all of my objections, like hearsay, or what did I say the other one was? Entrapment. I didn't use prejudicial effect outweighing probated value, and all the others I'm not even going to get into because they're stuff that you use in the courtroom. But that being said, per Florida Rule of Procedure 8.255 subsections B, 3, H, and F allows the court to grant a continuance in a hearing or before with a showing of good cause. Florida Statute 39.809 subsection 2 also states good cause may be granted as necessary for investigation, discovery, and procuring counsel or witness. I was incarcerated on allegations that led to a false imprisonment, which was expensive and hindered procuring a lawyer, where my Miranda rights were not read on new charges, and exit police interaction was impossible because I was taken into custody. Therefore, the police were required to read me my Miranda rights that day, and y'all are claiming that I was resisting arrest without violence when I was standing in the entryway of my family's recreational vehicle, and I have witnesses, and my phone also recorded the one that you all confiscated that day, which you had no right to do so because it wasn't evidence for anything. I was recording a video that under wiretapping laws, I had the right, as well as me being a public advocate, to put these videos out on YouTube like I do to inform the public of the law being broken under deprivation of rights, color of law, United States Section 242, Title 18, if I'm not mistaken. And I was ripped out of the recreational vehicle that morning, and that video covered it. The second half of the video, which we've already put out on YouTube, shows my ripped tank top, and you can see it's ripped from here at the shoulders, which is consistent with somebody grabbing your tank top right here and ripping it forward and ripping me down out of the RV. So forensic evidence would prove beyond a shadow of a doubt that that side of it is true. And this resisting arrest without violence is, it's just completely false, like the whole arrest process was. My charges were also enhanced without my peers being present or without ever having knowledge of quote unquote interference of custody being enhanced to quote unquote interference of custody with an incompetent minor. We're going into arraignment tomorrow. And, these are the charges and stuff that I'm facing. I should have been in front of my peers before the charges were enhanced. And you all have to notify me if you're going to do something like that. You can't just do it simply because you choose to. That's a violation of rules of procedure. And I was informed this by one of my witnesses who was unable to be present, along with a few others who were on short notice by way of unscrupulous suicide watch incarceration. Folks, I was placed into suicide watch. And now as you've noticed, I've deviated and talked about a couple of points as I'm reading this defense. We were in suicide watch with 90 people at one point because I counted all the suicide watch documents that were up on the door. And what they are doing inside that Polk County jail to some of those inmates, I'm sorry, it's completely inhumane. And even though, you commit a crime, you should do the time. Nobody deserves to be treated like that inside there, because y'all are just simply trying to make people lose their minds so that they'll catch more charges and y'all can continue to make money, like my shiny GPS monitor here when somebody leaves the jail on attempted second-degree murder charges, and y'all don't put them on a GPS monitor, but you got me on mine for being a good father, which explains why you would put 7 or more people in the same cell who are allegedly trying to commit suicide, so that they will what? Fight? So that you could place more charges on them, keep them locked up longer? That's a violation of many Florida mental health policies, as well as their rights and mine. I was held for several days with no phone call, mind you, locked up with those several people that I was telling you about. They even put me in with the individual who I've brought up in my prior videos who shot out my son's window. They put him in there with a group of his minions. I don't know what, to try and intimidate me. I don't really care, because I wasn't scared. Just like I'm not scared of you, Grady Judd, or any of your corrupt officials below you who are doing what they do for nothing more than to follow your orders, or whoever's got control of that little corruption button to try and ruin my family's lives. Well, I'm going to stand up to your tyranny until the day I die. We already know y'all want that to happen. I requested probable cause from the nurse who was observing our mental health, because I wanted to know why I was being held under suicide watch. And I was told by that nurse, quote, "Maybe you should have been nicer to your transport officer," unquote. Now, that's no reason to put me in suicide watch. I didn't say I was going to harm myself, not once. I didn't say I was going to harm the officer either. I did ask him some questions, though, of how he felt about the holy war that he was involved in, and if he was prepared to deal with the devil or deal with God for all the sins that he's presently committing and not standing up for real justice. But it is what it is. And the song that I was singing in the back seat by New Breed is "If I Die Tonight." And I was singing some of those lyrics. That song itself, though, has a very powerful meaning, because if I do die tonight, I'm okay with the choices that I've made, because I fought for truth and I fought for justice. And if my passing occurs, then I'm okay with this, because these videos will live, because I've got the rules of procedure as well as the Florida statutes and case laws that protect them, like McDade versus State. McDade versus State. If the people are not willing to protect you for your atrocities, atrocities, then you have no reasonable expectation of privacy. Given these exceptional circumstances, an attorney clearly needs to be procured. So do witnesses, and I also have to begin discovery on my cell phone, still being held by the Polk County Sheriff to date, who pocketed my phone per one of my children witnessing the deputy put it in their pocket. And they did openly admit that they do have my phone. And they said, quote, they're holding on to it because they don't know where I'm uploading the videos from, unquote. That's not probable cause to hold on to my phone, because the videos are public record. So y'all already had access to the information. But nice try, rookies. You also had no warrant, and my phone should have gone to property. I'm getting ready to go to my arraignment tomorrow morning for these criminal charges. And I already know where I'm going to go with the public defender route, and because that's what I have to do due to limited financial resources presently. So it is what it is, and that's the route that we have to go for now. But it's an entirely illegal process, from the arrest to, I just noticed in all this big old thick manila folder of paperwork that my ex-wife's attorney who represented her in court, her name is not on the documents. Also making this entire process entirely illegal, because I have to know the attorney's name who is part of this suit, who's coming against me. So I don't know how you all have gotten away with these indignities. No, I do know. Let me backtrack. I know exactly how y'all have gotten away with these indignities, because you control the Department of Children and Family Services in Polk County. You control the Lakeland Prostitute Department. You control the Polk County Sheriff. You control the courts, as we've clearly covered with all of our evidence here. So to sit here and say that we're slandering or not telling the truth, or that you all aren't paying off somebody or using some type of bribery, because my son has even come out in the videos and said that the petitioner is using bribery tactics to try and keep him there. Y'all go back and watch part 4, cognizable definition, from beginning to end, and you'll see it for yourself. But that attorney's required to provide her name, and I'm sure it's probably because I bashed her last attorney in a public review on Google, which my Google review account has been taken down. I can't make reviews anymore. And I had over 250,000 views on my reviews, which is experience. And Google violated their own policies by taking down my Google review account simply because I'm telling the truth. And I provided videos. I provided photographs to prove I was there in those locations and have experience on such. Or even, I don't have the links. I think I took all the links down out of my reviews. I'm pretty sure it's going to make me go back and check now. And I changed it to saying, you just need to go to YouTube and check out our War Against Corrupt Punk-Ass Chump series. Or look up MC Intimidator, War Against Corruption on Youths of Our Nation. Either way, it should pop up because I've got the hashtags there. But that account has been taken down. I'm being silenced everywhere I go simply because of what I know, what I can prove. And what I'm telling is beyond a shadow of the doubt the truth, along with the rest of my family. Yet you all are trying to silence me. Kind of like Grady Judd's running, or who was running against him when he was going for sheriff. They were harassed out of town. There's a Lakeland Ledger article that's already out that you folks can look up yourself and see that they were run out of town from being harassed. And it's no wonder Grady Judd became sheriff of Polk County. But I ain't scared of Shady Grady. No way. And if I die, you all are just going to confirm how real this really is and how big of a problem that man is going to be for society because of his twisted narcissistic thinking and that they are above the law. Y'all are guilty of committing treason because you're not following the United States Constitution. That's a white-collar crime. And even if y'all can't be punished by going to prison, y'all using the qualified immunity defense is entirely bogus because that has to be done under a jury trial per federal rules of procedure. And Mrs. Attorney that is representing my ex-wife, I'm going to find your name one day and I'm going to make sure to... Actually, you know, the feds are going to find out your name. We're going to be able to go back and hopefully get a copy of those court reportings from August 1st, which I doubt highly that they'll exist because y'all are going to get rid of it, which will prove beyond a shadow of a doubt you've tampered with evidence. And if you don't get rid of it, then y'all are going to hear how corrupt that court hearing transpired that day. So I wanted to come back and read the defense. I'm glad that I got to share it with everybody. The DeClaire family, we're going to tell their story next. I should have dug up the Ford emblem before I continued on with tonight's video, but, you know, I didn't. I know it's here because we've saved it, and it came directly from the Ford Explorer that mowed down a mom and two innocent girls. There's also news articles that came out on that. I don't remember which news companies covered it, but the police were saying, and the Department of Children and Family Services were saying, and I don't remember which one said that they darted out in front of the car or that mom pushed them out in front of the car. Yet all three of the victims, and I know this from experience because I took the father himself and rushed him to Tampa General Hospital where one of his daughters was med-flighted over there. Her brain swole extremely large and she was in a coma for many weeks. They didn't know if she was going to survive due to the swelling and the impact of her brain. Now, that vehicle traveling 100 feet, come on, man. I gave you all the formula. 30 miles per hour times 1.5 equals 45 feet per second. And if you lock up the brakes at that rate, you'll be lucky if you slide 45 feet. Y'all need to be going at least 60 or 70 miles an hour. And all three of the victims woke up in separate hospitals all saying the same thing. He ran the red light. He was speeding. And nobody took witness occurrences from that accident. So DeClaire family, I've got y'all's back. And from the anonymity perspective, I want to be clear to the Lakeland Police Department on y'all's botched investigation. This is my statement. This is my experience. I sat out there for a couple hours and watched you all release the guy driving the Explorer after you had handcuffed him and he was able to get in his vehicle and drive away. After he slid 100 feet. You have to be traveling at least 60 miles an hour. 60 times 1.5 equals 90 feet per second. Now you actually have the velocity necessary to potentially slide 100 feet. But a vehicle with anti-lock brakes is still going to be able to stop in under 100 feet. And that vehicle was equipped with anti-lock brakes. So even if he hadn't run the red light like all three of the victims stated, and y'all only took one witness account, when there was over 30 people standing over there across the street at the Stayable Suites, one of them was myself, and y'all didn't interview anybody properly. Y'all got the news in your pocket. Y'all got a lot of people in your pocket. But I'm here with my advocacy series with no fear, and we're going to stand right here. Goodbye, good night, Godspeed in the lives you lead.